Today's topic for discussion is analysis of cartel under the Competition Act 2002. Cartel actually it is one concept that prevailed in India and in other countries like US and UK also. But my today's discussion is focused on the concept of cartel, that is the conceptualization of cartel, the law relating to cartel, the cases relating to cartel, and the law what India is there and how it is going to be implemented and how much it is able to implement. So that is actually running through the Indian aspect only. So if we can come into the contents page, there will be a brief introduction about today's topic, then general concept of the cartels, the definition of cartel, historical background of cartels, kinds of cartel, common characteristics of cartel, conditions conducive to formation of cartel, types of anti-competitive agreement, and then comes the regulatory aspect and law, the role of Competition Commission of India, and then the cases based on this, the recent cases, and I will come into the conclusion of the session. Actually, Indian corporate sector, if we can take Indian corporate landscape, that has been dominated by two types of enterprises, that namely public and private companies. And as a student, I feel that many of you are students, so we know that what does it mean, that public company and private company. In case of public company, the minimum number of member to form a public company, that is, if we can go for private company, then it is going to be, it is generally even 2% can constitute a private. But if we can go for a public company, then it is 7 people, 7 minimum number is required. So in that case, the number of directors, the maximum number, minimum number, that is there. But why this thing? Because the ultimate sector-wise division in case of public and private corporations, public, it is representing the initial public offer, the representation of people, and through which the Indian Companies Act and Indian Company Law is going to be a democratic system like our democracy. If we can go the history, then after independence in India, the Indian economy is basically, before and after both, it is influenced by the British socialist pattern. Because as we know, that in the 1600 BC, that Britishers came into India as a business concern, which is known as that is East India Company, and that is a chartered company, and it became a ruler. It became actually that they came as a company and they have turned themselves into the ruler of the country, and they ruled us for near about 190 years. And why this economy? Because once upon a time, the British Companies Act was applicable to India. That was the history. If we can go into more detailed in it, the British people, with their mechanism of industrial revolution, they have done a lot, and then they are trying to implement the business and industrial developments in India. The result of that is the Indian Railway that came during their period of time. The government of India, when the India government formed after the constitution came into existence in 1950, in the post-independence era, they have implemented the command and control policy in case of 5-year, through the 5-year plans. And initially after independence, the Industrial Development and Regulation Act, which known as the 1951 Act, the Industrial Development and Regulation Act, it was enforced. This act regulated the economic policy framework, and then there was a committee known as Hazari Committee, because these committees developed Indian legal system. They have some recommendations. So Hazari Committee was constituted in 1951 to study and prepare report of the licensing policies under this particular act, that is the Industrial Development and Regulation Act 1951. That committee in its report condemned the fact that government control and undue interference prevailed in all areas of working of corporations, and the corporate houses need license for every small affair. So Hazari Committee found that in its report, they have condemned also that there is a government control in everything. Before 1992, from 1947 till 1991, India was under the complete governmental regime of economy. So everything The licensing system is also on the basis of the choice of government. If government will give preference to a particular sector of business houses, then they can perform. There was no competition much in the market. And when we are discussing on cartel, which is a part of competition law, that's why it is required, because competition was not there. Then that Competition Act came in 2002 to brought the competition in the market and how much it is able. So the committee in its report condemned the fact that government is having control and undue interference in case of choosing the working of the corporations, and the corporate houses need licenses for every small affair. If you want to start a business, even if you are going to start a small business, you have to take government's permission, and that is going to be a very critical way to take their permission. Government used to support the big business houses as they largely contributed to the growth of the economy. For them, obtaining licenses and permissions became a cakewalk. So soon it led, so for few of the big houses, it is very easy to get, and soon it led to concentration of economic power. And that's why economic power is concentrated in the hands of few. And that point of time, all the business houses, those who were not being treated as a company also, some are from joint Hindu undivided family business to become a company. And then from company that they are going to be the preferable companies of the government of choice. So that is the history. And these create a monopolistic environment, and these monopolistic industrialists started indulging anti-competitive activities which were detrimental to the general public interest. Suppose if you need something, then you have to buy from a particular individual person, and that person is the producer in the market. So it was also against the sacred principles of our constitution. When our constitution formed, our constitution has given right to equality, and then Article 19 has given the right to do business profession, and it is equal to everyone. So these are against the basic ethos of constitution, which is treated as the Bible or Gita or Quran, whatever. That is the sacred book. Sacred means it is the law of the land. It is the basic, we can say, organic document, which is having the constitution is not, it is an organic document. So there is organic development. So it is going to be one of the thing that actually going against the basic ethos of constitutional principles. And this scenario ultimately led to the formation of the MRTP Act, which is, in short, it is known as MRTP Act, and in detail it is known as Monopolies and Restrictive Trade Practices Act 1969, which came in the year 1960. The introduction of competition law in India, that has been inspired by the directive principles of state policy. So before the Competition Act came into existence, the Competition Commission of India Act, CI, in 2002, before that there was only law, that is the MRTP Act 1969, Monopoly and Restrictive Trade Practices Act 1969. So the introduction of competition law means they are referring the MRTP Act first. That has been inspired by the directive principles of state policy that form the part 4 of the Indian Constitution. Article 38 and 39 of the Constitution and inter alia state that the state shall strive to promote the welfare of its people and shall secure social, economic, political justice for its people. And this social, economic, political justice, if you can remember, it is the part of the preamble of Indian Constitution. So when the Indian Constitution is speaking for social justice, economic justice, then you have to think about that whether monopoly is existing in Indian market or not. So that is required. The separate law is required, and that's why MRTP Act came into existence. Then next is the nation's resources are distributed judicially and effectively in a manner that best serves the interest of the people. That is going to serve the people best. So whenever you are going to distribute the resources, whenever you are going to distribute the assets, it should serve the people's interest. That's why the PDS system that has been done. So what is the ultimate need? Need is the people of India. The operation of economic system should not result in the concentration of wealth in the hands of few. Because if there is a concentration of wealth in the hands of few, then they can misutilize that for their own purposes, and it will create a commodity. Now, in that case also, any formal or casual arrangements between different enterprises dealing in similar kind of business to control prices of product or sale of product might be generally called cartel. So if we can go into the common or general definition of cartel, then we can find that any formal or casual arrangement, maybe it is a formal, maybe it is a casual, but there is an agreement between the parties, and that ultimate thing is to effect some price, fix some price. So that should come through. So any formal or casual arrangements between different enterprises dealing in similar kind of business, they are not dealing in different kind of product. Suppose if I am going to take this area where I am sitting right now, where the ICFAI is situated, Kamalghat. This is a very rural area, and in that rural area, if you can go, if a medicine shop is one only, and that medicine shop owner is trying to create that impact in the mind of the people that he is the only medicine shop owner, then that ultimately that will hamper the interest of the people. So the same thing cartel is going to define, and this is probably a mode used by corporate houses to control market pricing or any other relevant factors that is required for free market competition. It is not going to be free market competition where everyone can join, everyone can go for their shares, everyone can go and join the business with their particular items. So that it is required for free market competition, and thus cartels adversely affect the free market competition. There is no doubt in it. And as whether cartel is good or bad, then it is one word thing that cartel is not going to be an acceptable aspect in the business. In other words, cartel is an agreement or type of arrangement between the competitors related to a particular sector of the market for not competing on price, consumers, or in markets. So definitely, it is the thing, and that's why this thing we are discussing right now. It is considered as the worst form of anti-competitive practice. If we can discuss the anti-competitive practices, there are other anti-competitive practices also, and cartel is definitely one such anti-competitive practice. And definitely it is one of the worst form of anti-competitive practice because it reduces the benefits in case of competitive pricing, bargaining power, and it eliminates benefits. That is the competitive pricing, better quality products. No company will come with good product. Nowadays, there is a thing that when you are using any service or product, both the things will come in the product market nowadays. Because if you are using Swiggy or Zomato, it will also be, or Ola, it will also come with some feedback form. So why that feedback form? To develop their quality, and that is for the greater benefit of the society, which is missing here. So it is considered as the worst form of anti-competitive practice as it reduces and eliminates benefits of competitive pricing, better quality products, and options to the consumers, and thus acts against the objective and purpose of competition in the market. Generally, cartels include agreements between business representatives not to rival each other, and cartelization can happen in any industry and can include products or administrations at the assembling, conveyance, or retail level. So how it will be done? Cartelization can happen in any industry. It is not only one sort of industry, that food industry, cloth industry, in any industry. And it can include products or administrations, because products, in case of service, it is not product, it is the administration. And both the things are in case of products, there is a question of assembling, conveyance, or retail of that product. In case of cartelization, these things are very important points. If we are going to define cartel, then now I'm coming into the legal part, and definitely I'm entering into the Competition Act 2002. As per Section 2C of the Competition Act 2002, and in that section, it is clearly explained Cartel includes an association of producers, sellers, distributors, traders, or service providers. Because as I have mentioned, as per the Consumer Protection Act, now services also comes under, and this age is actually the age of services more than products. Flipkart, Amazon, Netflix, Jio, everything. Yes, just repeat the 8th slide. So cartel includes an association of producers, sellers, distributors, traders, or service providers who by agreement amongst themselves. So there is a hidden agenda agreement between themselves. Limit, control, or attempt to control the production, distribution, sale or price of, or trade in goods, or provision of services. So that is actually to restrict the business activity, and that is defined by the Competition Act 2000. History of cartel, if we can go, in England, it started in the Elizabethan era. And if we can go, the Elizabethan era that witnesses the industrial monopoly, licensing in early 1951, even before the passage of Sherman and Clayton Act, because Sherman and Clayton came into USA later on, but Elizabethan era during the time of Queen Elizabeth, there is a favor from the royal. So it is known as the favor from the royal. So Queen is favoring some of the business units. So this licensing system, it is not in India only. This licensing system can be said to have similarity with our modern patenting process. But this system could not stand for community good, as Queen Elizabeth is that used it for favors to the throne. So that is the ultimate thing. And the statutes of monopoly that was later passed in 1653 when the parliament came into power, and these statutes saved the patent rights from undue restrictions. And that is the English law that came first, and that is the history of cartel. We cannot ignore that it is not in our India, but these things, these concepts are developed from Britain only, because the British English company law that was followed by India even till 1950, 51, or even after the constitution came into existence, few provisions, and then in 1957, the first Indian Companies Act came when Dr. B.R. Ambedkar was the law minister. With the coming of Sherman Act, the concept of modern competition law that arrived, and Clayton Act confirmed specifically that no merger must take place which adversely affects competition. So this Competition Act or competition law is not only for restricting anti-competitive agreements like cartel or anything. It is more important than the Sherman Act, Clayton Act, what they have defined. You can find these things, that anti-competitive agreements are there in US also, in UK also. And with the coming of Sherman Act, with the coming of Clayton Act, they have specifically said about the business mergers, because business merger, that is another sector, corporate finance part, merger, acquisition, and takeover of businesses. So that part, if two companies, they want to come together in a particular mode, then we have to remember that they should not leave their main aspect of business, and their fundamental rights should be maintained. So merger must take place which adversely affects competition. Hence, an exclusive protection against anti-competitive practices and cartels were extended in the was extended in the act. So that was more strictly deal this particular term cartel. It is not going to be given any scope. And later, most of the civilized nations followed US laws regarding competition and framed their own comprehensive legislations on competition. In India, MRTP, as I have mentioned, it was enacted in 1969, but it has no express provisions. And even in MRTP Act, if you can go into the MRTP Act, you will not find a single word relating to cartel. But it was defined, the Competition Act has defined in 2002 and brought out these concepts and provided schemes to regulate them. That is if we can go into the kinds of cartel, basically these types of agreements can be entered into by either two or more enterprises established in the same jurisdiction or nation, or enterprises from different nations can enter into agreements to strengthen their position globally. So the latter is also called international cartel, as companies from different jurisdictions participate in it, because this is the age of international business. Before starting of the session, I am discussing the same thing with me. This is an age, this particular age is a business, that foreign trade, then international commercial arbitration. These are the subject matters. So this particular policy has to be open, that if any foreign country, it will create or trying to create any cartel in Indian market, then how you are going to deal with. So it is the international cartel is one of the types of cartel that have been fixed by the Indian system. Also, the classification of cartel might be based on the field of business. That is to say, if the cartelization between enterprises occurs with the motive or import goods or services into a country, then it would be called import cartel. Similarly, if it's related to export of goods or services, then it is named as export cartel. So both the things are applicable, export cartel and import cartel. Common characteristics of cartel. So in that case, usually cartels function in secrecy. So this is, we are always saying now what are the features, what are the character. So this is the character of cartel. Cartels are always going to work in secrecy. The members of a cartel by and large seek to camouflage their activities to avoid detection by the commission. They are trying to hide themselves. And it is actually an act, it is that much of thing that they are trying their level best to hide their face. Perpetuation of cartels is ensured through retaliation threats. If any member cheats, the cartel members retaliate through temporary price cuts to take business away or can isolate the cheating member. So always there that particular group of businessmen, service provider, they are trying to create a tendency in the mind of their the other group members that you cannot violate the principle. You have to accept it. This is the business norm. You cannot mention anything to anyone. We are hiding ourselves and we will go for greater, whatever the profit, and then we will divide amongst ourselves. And another method known as compensation scheme is resorted to it in order to discourage cheating. So this is the thing, that if someone is going to cheat in the business and is going to leak the story, so that is also having some punishment from their side. And under this scheme, if a member of a cartel is found to have sold more than its allocated share, it would have to compensate the other members. So that is, these are the norms. These are not written norms, because these are illegal things that they are running amongst themselves, and they are maintaining. These are the basic characteristics. Now, everywhere now, suppose in the time of rain, snakes are coming into houses. That is the common perception of people. So if you can go, some of the conducive conditions are there when cartel or this sort of illegal activities, this sort of activities in the market, it may increase. So high concentration of few competitors. If in a market only 2-3 business names are there, big names are there, then you can easily understand that this market is not fair enough. It will not give justice to the buyers, as well as the product manufacturers, as well as the other people who are connected with. High entry and exit barriers. There is definitely people or companies will join together and they will leave the market suddenly. So that tendency is there. Homogeneity of products. The product that they are dealing with, that is of the same nature. There is not much different. Similar production costs are maximum cases very nearer. Excess capacity, high dependence of the consumers on product. They are depending on the products much. And if the product is not available, then the consumer can do anything for that. History of collusion, active trade association. Yes, trade associations, they are violating these norms, and they have created the anti-competitive atmospheres in case of, I have mentioned, and through the cases also I will discuss, I will give some light on that. In general, if we come into, if we are discussing about cartel, then cartel is a type of anti-competitive agreement. But general curiosity may come in the mind of the participants that what is that? What is actually the other types of competitive or anti-competitive agreements? So if we can come into section 3, subsection 4 of the Competition Act 2002, they have given 4 or 5 such things like tie-in arrangement. It includes any agreement requiring a purchaser of goods as a condition of such purchase to purchase some other goods. It is not like buy one, get one free. It is not buy one, get one free. Rather, I can say in Flipkart nowadays, the conditions are coming frequently buying options. This is also not covering that. It is the restriction. It is the restriction imposed by the businessman. If you are going to buy that product, you have to buy this one also. If you are going to buy 1 kilo of sugar, you have to buy 500 gram of jaggery also. Exclusive supply arrangement or agreement that includes any agreement restricting in any manner the purchaser in the course of his trade from acquiring or otherwise dealing in any goods other than those of the seller or any other person. Exclusive distribution. So that exclusive supply means includes the agreement restricting in any manner the purchaser in the course of his trade from acquiring or otherwise dealing in any goods other than those of the seller or any other person. So you have to, in case of dealing with business, you have to deal with my business only. You have to marketize my business only, my product only, not others. And for that reason, you can come into contract. I will give many money. What you want, what type of amount you want, I will give. I want, and then if it is not a factor of money, if some other forces are there, I will try my level best to close those forces or stop those forces from inquiring into the subject matter, because inquiry is the ultimate thing. And then exclusive distribution agreement that includes any agreement to limit, restrict or withhold the output or supply of any goods. So you know that a product is there in the market. Just now recently, the flood was, havoc flood was there in Tripura. It took place a week ago. And suddenly the essential commodity prices increase. Essential commodity means the rice, the pulse, the oil, the egg, soybean, etc. Food items suddenly, and it is found that it is like that same thing. It is some man-made thing, artificial thing, and that the same thing done Due to this exclusive distribution agreement, it includes any agreement to limit, restrict, or withhold the output or supply of any goods. Products are available in the market, but supply that has not been done to or allocate any area or market for the disposal or sale of the goods, or that has been selected in a particular area, the goods will be served, and that is with a higher price. Yes, next slide. Refusal to deal. That includes any agreement which restricts or is likely to restrict by any method the persons or classes of persons to whom goods are sold or from whom goods are brought. So it is working in both sides, vice versa. And this anti-competitive agreement, like cartel, refusal to deal, that I am not going to sell your product or I am not going to buy your product. The same thing. And resale price maintenance, that includes any agreement to sell goods on condition that the prices to be charged on the resale by the purchaser shall be prices stipulated by the seller unless it is clearly stated that prices lower than those prices may be charged. So there is a tendency that if I am going to buy this product from him, it is not he is selling the particular product in the market price, but I will get this product from somewhere else less than the market price. And if this is going in a market for a long time, it is also not been acceptable, and it is also an anti-competitive agreement. So now I am coming into the regulatory aspect, that the role of Competition Commission of India in that case, if we can come into the point, some more points are there. If we can discuss that how the tendencies are going to be fixed. That inquiry is a particular point that has been given. The powers in exercise of the power of the CCI under section 19 of the Act, that the Commission may inquire into any alleged contravention of the provisions of Section 3 of the Act, which inter alia prescribes cartels. Now, when there is a suspicion in the mind of the Commission, under what circumstances the Commission may suspect someone, like creation of barriers. There is a constant creation of barriers to new entrants in the market, as I have mentioned. If the new entrants in the market, they are going to be stopped together totally, that no new market participant is there, and only one particular person, he is competing, he is running the business. So it is ultimately the monopoly. It is not going to be the absolute market condition. The Commission, on being satisfied that there exists a prima facie case of cartel, that shall direct the DG. DG means Director General, to cause an investigation and furnish a report. And that is asked by the Commission in that. The Commission has the power vested in a civil court under the Code of Civil Procedure. Now, the procedure run under the CPC also. And civil code under the Code of Civil Procedure in respect of matters like summoning or enforcing attendance of any person and examining him on oath, requiring discovery and production of documents, and receiving evidence on affidavit. All these parts, affidavit, receiving of affidavit, summoning someone, these are part of CPC. So for the implementation of the CCI, Competition Commission of India, or Competition Act, then we need the support of CPC. Without CPC, it is not possible. In that case, the Commission's powers are also very important. Commission is empowered to inquire into any cartel and to impose on each member of the cartel a penalty up to 3 times of its profit. So by using the method of cartel, whatever they are earning, whatever they are actually raising their capital, that can be stopped 3 times of the profit for each year of the continuance of such agreement, or 10% of its turnover for each year of continuance of such agreement, whichever is higher. So that the penalty is in terms of money, and it is that we can say whichever is higher principle applicable, but automatically it shows that it is a civil punishment. In case of an enterprise is a company, its directors or officials who are guilty are also liable to be proceeded against, because the directors and officials, they are treated as the brain of the particular company. They are the decision makers of the company. They are the management of the company. They comes under the centralized management aspects of the company. In addition, Commission has the power to pass inter alia any or all of the following orders, which comes under section 27. Direct the parties to cartel agreement to discontinue and to not to re-enter such agreement. So it is only possible when it has been detected. And after detection of such thing, that they are going for the agreement is going to be a cartel, they found it, and they will ask for discontinue with that particular company. Direct the enterprises concerned to modify the agreement, to change the agreement, and that will be decided by the Competition Commission. Direct the enterprises concerned to abide by such other orders as the Commission may pass and comply with the directions, including payment of costs, if any, and pass such other order or issue such directions as it may deem fit in that regard. So it will be decided by the commission. It is not been imposed by the law. Leniency scheme comes under section 46. This is another way or moderate order to deal with the things, that section 46 of the act, which empowers the commission to grant leniency by levying a lesser penalty on a member of the cartel who provides full, true and vital information regarding the cartel. The scheme is designed to induce members to help in detection and investigation of cartel. This scheme is grounded on the premise that successful prosecution of cartels requires evidence supplied by the member of the cartel. So it is like we can say acceptance of the guilt, and when the particular members of the cartel, they can confess that yes, there was a cartel and I was an active member or passive member, I am having involvement in it. And this scheme is grounded on the premise that successful prosecution of cartels, that cartels should be prosecuted. Similar leniency schemes have proved by helpful. It is very helpful to competition authorities of foreign jurisdictions in successfully proceeding against cartels. So it is also applicable to the foreign market and applicable to provisions being given that the international commercial arbitration, what I am discussing that few minutes back, that this is the modern age of business. So that should be done with. And section 46, the leniency scheme, is one of the very important aspects that how to restrict the cartel. And these are the mechanisms, these are the weapons in the hand of Competition Commission of India. The Competition Commission has notified the Competition Commission of India Lesser Penalty Regulations 2009 that laying the process, procedure and methodology for granting leniency to the cartel members who break the ranks of the cartel and become helpful to the commission and instrumental in busting the alleged cartel. So this is the Competition Commission of India Regulations 2009, where the process have been enshrined and the procedure of methodology for granting leniency to the cartel members who break the ranks of cartel. There are norms being given. Some are legal and some are illegal. And if you have violated that norms, that will be treated as an illegal cartel. Under section 33 of the Act, during the pendency of an inquiry, the commission may temporarily restrain any party from continuing with the alleged contravention. So you cannot continue with the same business. And until the conclusion of the inquiry or until the further orders, because there may be that they may say in the court of law that if I am going to stop the business during the proceeding going on, during the procedure going on, then how I will continue with my bread and butter? This is my bread and butter is completely depending on this business. So that will not be applicable, because always some exceptions are always there, and the fundamental right of freedom of trade and business, these things are not always acceptable. So that has been given under section 33. In case of Competition Commission of India's role, appeals are also going to play a big role, because appeal is a fundamental right. We know that appeal, right to appeal. So the Competition Appellate Tribunal or COMPET is established under the section 53A of the Act to hear and dispose of appeals against any direction issued or decision made or order passed by the commission under specified sections of the Act. An appeal has to be filed with 60 days of receipt of the order, direction. So this is the limitation period that has also been mentioned in case of order, direction or decision of the commission. That is the role of the Competition Commission of India. So if we can go into the cases on cartel, then there are certain products as well as services. I have mentioned that the cartel is specifically applicable in case of service sector. There are truck operators cases. Truck operators, they are running trucks in particular areas, and that the cases of Himachal Pradesh in Baddi, Nalgar Truck Operator Cooperative Transport Society, they have monopolized the movement of goods from one state to another. So that will create a restriction in case of interstate trade and commerce, which is against the constitutional ethos. Controlled by the local MLA, the truck union charges 30% higher freight on the Baddi Delhi road. So there is a political nexus also. And 50 to 20% of the Baddi Mumbai road. Trucks coming in with supplies go back empty because they are not allowed to pick up freight, which only adds to the cost. So these are contractual cases, but this is a complete restriction due to the cartel created by these particular people of Baddi, Himachal Pradesh, who are dealing with the truck operator Cooperative Transport Society and the local MLA. In the case of Odisha, in Odisha also in Angul Truck Owners Association case, a government registered body operating at the National Aluminium Company Limited's factory charges as much as 200% more for transportation of ingots under the obliging eyes of the authorities. And that is, yes, it is actually to hide the particular procedure of the authority. Such official cartels are known to exist in other parts of Odisha also, like the Shukinda mines, Paradip port and Balasore. These are the industrial belts. In Punjab also, in Punjab's Deravasi, truck unions have drafted their own tariffs, increasing costs of production for local units, thus rendering them uncompetitive. A cartel of around 500 truck operators has been troubling the area. So that 500 truck operator, they have created a cartel and they are creating trouble for the residents of that area, Dharavasi, which is actually incepting an industrial town in 1987. It is earlier than the many days. In Sirhind, in near Mandi, Govindgarh, such unions stalled. So that is the truck unions. They are creating problems in various parts of India. That is the ultimate thing. In vitamins cartel also, the duration and effect, the vitamins cartel to fix prices, that is not in India, in outside India also, that allocate market shares for the sale of certain vitamins operated from 1990-1999. Annual global sales over the conspiracy period were US dollar 1.3 billion, and the price increase generated by this cartel, that has been 64 estimated to be 35%. So there is a big gap. In the US alone, this cartel may have produced US dollar 500 million in the overcharges. Impact in the developing country of that cartel, the aforementioned high overcharge of vitamins. It is a medicine. Definitely impacted developing countries in view of the fact that developing countries imported around 6.6 billion US dollar worth of vitamins in the course of their conspiracy. So this is a conspiracy created by the vitamin sellers, and due to that, the developing countries, US, UK, and that they have faced, and US, Canada, EC, European Union, Australia, South Korea have each investigated and prosecuted the cartel for its effect on their domestic market. The US and European authorities have fined the cartel approximately 1 billion US dollar and EC 85 million respectively. So the Korea Fair Trade Commission, it is a commission like Competition Commission of India, they have imposed corrective measures and civil penalty. They are saying civil penalty. To the amount of, in India, there is no such civil penalty, but amount of 3.9 billion Korean won. Brazil, Japan, and Mexico are reported to be investigating that affair, and that is the sanction from those particular economies. If we can come into the Indian cases of recent origin, then Somu Pillai versus Municipal Council Mayavaram, that court held that if an agreement is conflicting with the public policy means definitely the Constitution of India, the recent criminal laws of the country which were adopted in July, information of monopolies would be void. So it is in this case that monopoly is completely restricted. Bholanath Shankar Das versus Lakshmi Narayan, the right of an individual to carry business activity and accountability along with certain principles determined, and it was also realized in Bholanath Shankar Das case that for strong and fair rivalry, a better regulatory and adjudicatory mechanism is required. So for better competition in the market, a better adjudicatory mechanism is also been required. That has been developed in the Bholanath Shankar Das versus Lakshmi Narayan case. Next, in Union of India versus and others versus Hindustan Development Corporation and others, Supreme Court identified three important ingredients for cartel, that is equal price, mutual action regarding conspiracy, and control rivalry. But the charges of cartel could not be acknowledged. So Supreme Court's decision is there that important ingredients for cartel, that is equal price, mutual action regarding conspiracy. So for that thing, it should be proved. And then the cartel could not be acknowledged other than that. And in DJIR versus Modi Alkali and Chemicals Limited and others, in this case, an unknown complaint taken by the unknown complaint, there is no name mentioned, taken by the Competition Commission, because Competition Commission should be active. Now, what problem that the India is facing for last couple of years, that the Competition Commission is not taking much cognizance in the subject. Very recently, there was a certain, if I am not wrong, Hindenburg scam came, that allegations were made against the CEO of SEBI and her husband. So the SEBI, the Competition Commission of India, these are the regulatory bodies in case of market manipulation or securities market. They have to take care of these things. And competition market is nowadays, it is increased. Even if you are going to buy your flat, so you are taking the suggestions from the real estate market people, DLF, and the DLF has also committed some scams in this regard. So in this Modi Alkali Chemical case, that in the case, an unknown complaint taken by the commission regarding cartel and increased prices of products, but informant could not prove intention among players. Therefore, the charge was dropped in case of. In American Natural Soda Ash Corporation, ANSAC versus Alkali Manufacturers Association of India, AMAI, and others, ANSAC, the Supreme Court held that MRTPC is the earlier act before the Competition Commission, does not have any additional territorial authority to manage imports, but if wrongful acts is done by an Indian, then it may be considered, hence the court reversed the order. So in that case, American Natural Soda Ash Corporation, the Supreme Court held that the Monopoly and Restricted Trade Practices Act does not have any additional territorial authority, because that was the Act of 1969 to manage imports, but it was converted. That case, I can remember that case was converted to the Competition Commission of India when CCI was started in 2002. And imports, if the wrongful act is done by an Indian, then it may be considered, hence the court reversed the order. In Builders Association of India versus State of Kerala, this is also a real estate case. It was found that the opposite parties did not indulge in violation of Section 3, and further the information also does not reveal any consent between the players. So this case has given the complete idea that it is not only mere allegations will prove that it is a cartel. Even if after the inquiry is made, it is found that there is no such violation and there is no indulgence and there is no mens rea, so it is not been proved. So in my concluding remarks, I can say that whereas the difficulty in achieving optimal deterrence provides for a convincing argument in favor of the criminalization of cartel activity, such a move is not easily implemented. So in India, what is required that to make the act of cartel as criminal act? And if you can go into the Competition Commission of India Act, CCI, or competition law, you can find that right has been given. Competition advocacy provisions been added, and many chances been given to all the law schools, all the people of the law schools to increase the education relating to competition law, to conduct the events like debate competitions, moot court competitions, or many other events relating to this competition commission or competition law. And the criminalization of cartels cannot be limited to a technical discussion on how to best deter cartel behavior. One must also consider the jurisdictional conditions, because what we are taking in India right now, the government of India is planning to implement cryptocurrency. And it was the last budget session. They have given a norms also to prepare a law on cryptocurrency, to make a law on cryptocurrency. Last means 2023 budget. I'm not speaking about 2024. And the finance minister, Nirmala Sitharaman, in her budget speech she has given. But this earlier the scenario was not there. Now when the crypto will start, then the foreign crypto will also come in India. So you have to maintain the competition market and the chances of violation is more. So you cannot restrict it only on the jurisdictional boundary. Jurisdictional conditions already many days back it was deterred. It was already broken. Now jurisdictional conditions required for a successful criminal regime. Now how to implement the criminal law? So in that case the BNS, which is a new law, came into existence. I feel that provisions should be added regarding that, including the social context of criminal enforcement, the design of substantial provisions, because the law relating to cartel is very strict in US. And in one discussion, it is not possible to discuss the foreign aspect. But if I will get a chance next time, I will discuss that also. And the social context of criminal enforcement, whether it is possible to implement India, what are the loopholes in case of Indian system to implement that. These things will come, but automatically our legislatures have to give answer. The design of substantial provisions and the institutional and procedural nexus, that is the main thing that we can see in the Himachal Pradesh case, in the Baddi case. There is a nexus of MLA with the Truck Drivers Association. So if these things are going to prevail in case of freight charges, then the scams will do. And other than that, it is a scam, and we should go with more strict actions for. That is the concluding remark from my side. Thanks to all. If you have any query or doubt, thank you.
So there's a question in the chat box. Which country, according to you, has the best practices against this cartel system?
Till now, United States of America through their Sherman and Clayton Act, and that is practiced very nicely. That is my own.
And so one other question, in which court can we file a complaint, consumer court or civil court?
No, see, that Competition Commission of India is a very much active body, and it is having powers also. It is not like it is only you can go to the consumer forums are there, consumer matters you can go with them. But Competition Commission, when the Competition Act came into existence now, if you can go into the Competition Act, you can find the powers been given to the commission. And as I have mentioned in the particular slide also, that the role of Competition Commission of India, on the basis of your complaint, they can act. And if you are not, suppose when you are filing any application to Securities Appellate Tribunal, it is a tribunal which is dealing with the securities matter under the banner of SEBI. The same thing they are doing, Competition Commission of India is doing in case of competition cases. So if the business is such nature, you can go to the CCI, and in appeal you can go to again to them, and then if you are not satisfied, then always Honorable Apex Court is there to hear all the issues. There is no question.
Good afternoon, sir. Sir, it was an enriching session, and I'm really thankful that I could attend the session. So the question that I have right now is that there is a very large section of our economy which is in the informal sector. So for the informal sector, how does the cartel regulations and these acts, or how can we actually implement the cartel, and how could we use the Competition Act to legitimize the cartels, or illegitimize the use of cartels? Sorry. Yeah. Thank you.
Actually, your name is Pranav Tyagi, na? Pranav. So in that case,
Yes, sir.
I can say one thing. Like, if you can go into the act, do you have the Competition Act? You can download also from internet. It is available. One provision been given, I feel that is 25, section 25 or so, competition advocacy. Okay. So in competition advocacy, it has been clearly indicated that program should be organized by various organizations, NGOs, law enforcement bodies, national law schools, student bodies, law schools. They can conduct debate, they can conduct symposium, they can conduct national moot court competition, and even they are sponsoring also. So ultimately, because India's main heart is actually situated in villages, so they can conduct programs through the legal aid clinics. Now, legal aid clinics, they can ask the support of Competition Commission of India, CCI. You can directly write a mail to them, and Competition Commission of India will give you, sponsor you, or give you some resource person. They are always supporting, and to conduct events, to conduct the programs, because unorganized sector, they are basically residing in villages or rural areas, or
Yes, sir.
not in the mainstream of line, means metro cities, outside of the metro city, in some small cities. So you can conduct those events, and that is the responsibility of basically the legal aid clinics. When the legal aid clinics are performing under the Legal Service Authorities Act, on the same verge, they can conduct events with the help of Competition Commission of India to actually to inform the people about these, because the same thing is applicable in case of Securities Exchange Board of India, SEBI. SEBI, why the people were victim? Because they don't know about SEBI is there, and they are investing in the securities market, in the cheat funds, in the various schemes. And how they are going to be identified? Because the SEBI got to know that the Indian people who are actually investing in the securities market, they are the small investors, and they are residing in villages. So afterwards, the SEBI has started a procedure that in the local languages, the SEBI manuals been drafted, and that has been shown in the local channels. What is the reason behind that? To understand, for better understanding. And yes, Government of India should take initiative, as well as the provision given in the competition law, Competition Act, regarding that particular point, that is competition advocacy, that should be exhausted by the people. By the people means the law schools, the law students, the law enforcement bodies, and everyone who are interconnected with. I feel that you got your
Sure, sir. It was really helpful. Thank you, sir. Thank you for the session again, sir.
So the next question is, what kind of evidence should be submitted against this cartel?
See, in that case, as I have mentioned just now, they are inquiring into the matter, and section 33, I feel 33, they have given 46 also leniency provisions. So, in that case, evidence, if anything is there, that can be produced. And Competition Commission of India, though it is not a judicial body, it is a quasi-judicial body, but it should, it is their function that they will follow the procedure established in the CPC and evidence. As I have mentioned, the mentioning of Civil Procedure Code is also there. So as per the evidence law, as per the Sakshya Adhiniyam, recent Sakshya Adhiniyam, it is now no more Evidence Act. Is now Sakshya Adhiniyam. Whatever the electronic evidence or oral evidence or any other type of evidence is there, the CCI will accept that, and on the basis of that, they will take action.
And so, who is an aggrieved party in this case? Who can file a court complaint?
See, that if it is going to be relating to service matter or it is relating to any product, the victim, they can directly go into it. Victim means, see, it will depend, and it will depend on the fact to fact, case to case. It will not be similar every point of time, because I have discussed many of the anti-competitive agreements, the nature of the anti-competitive agreements, and sometimes it is both the supplier and the producer, both their rights are going to be infringed. So in that case, anyone who feel that he is a victim, he is an aggrieved CCI, and sometimes CCI take cognizance suo motu also. There are cases also, but today as time is limited, it is not possible to show all that.
Okay, sir.
Sir, very good afternoon.
Good afternoon, sir.
Sir, it's a wonderful lecture. Sir, I want to know, is there any similarity between the Consumer Act and the Competition Act? As you said rightly, that aggrieved party, it was my question only. So aggrieved party is who has given purchased the services.
Generally, in my university, this paper name is Consumer and Competition Law.
Okay, sir. Okay.
This paper's name is Consumer and Competition Law, which is a honors paper in BA, BBA, LLB honors students. Now, thing is that why consumer term has been added and what is the connection between the two? In 2009, there is new Consumer Protection Act came into existence. Before that, the 1986 Act was there. And for the first time, the new Consumer Protection Act 2019 has defined the idea of consumer in a different way when the idea of product and service, because earlier deficiency in product was there, not deficiency in service. But after the starting of the online product and all, the deficiency of product and service is there, and they have included it. So if we are, it will not be wrong if we can say that both should go hand in hand. Now, Consumer Protection Act is having a different aspect because they are running through the commission, consumer forum and all. And Competition Commission is actually or specifically dealing with those particular sectors, those who feel that they are going to be cheated or they are not able to do business or any of the anti-competitive or restrictive practices going on in the society for which their business is going to be restricted. So there is a specification on the line of businessmen that they can choose Competition Forum, Competition Commission of India as their best friend rather than this consumer.
Okay, sir. So in a supplementary question according to this, sir, then nowadays we can see that there are hardly 3-4 companies of service providing for the telecommunication, like Idea, Vodafone, and the BSNL and
they
Jio.
Have filed. And see, this is I can understand your question. Okay, you finish. I'll tell.
Yeah. So no, you understood my question, sir. So all they are 4, they must have done the cartel, I think, and they have raised their tariff also.
This is not actually, you can understand on which angle I am saying.
Okay.
This is very unfortunate, and that is I have mentioned in the Buddy case of Himachal Pradesh, a small thing, that local MLA is a party in there. If any sort of, see, I have mentioned in the question of Pranav also that we need a joint action in the side that all the law enforcement bodies, government, and definitely the student also, they should participate for conducting legal aid clinics and all. So government is a party. If government or anyone from the government, or if anything from the side of the government, if in case of giving any tender from the side of the government, if any sort of violation is there and any sort of manipulation is there to provide help to a particular or to a section of the business house, that was the defect earlier in our society from where I have started during the British regime, after the British regime, during 1951, that the licensing system. And in today's aspect also, if today also we are going to continue with these things, then it is very unfortunate. See, it is only that not only 2 or 3 telecom company or telecom sectors. It is many other aspects. If only one particular businessman or business house will get preference, then the entire country's economy, see what will happen. I have mentioned that the job sector will be shortened enough. The people will only get job in a particular sector. No other company, no other sector is there. And the thing what just before of this session started, Madam is asking, and I am just discussing unofficially about the condition going on in Bangladesh. The same things may happen in India also, because the political party or political person's connection with the businessman and to make profit for them. It is for few angle, for the election purpose, for something it is good. And already we know that in company law, the provisions are there of corporate social responsibility section 135, where political funding are there and it is accepted by the political parties. But this type of nexus in cartel is never going to be acceptable in any case, sir. It is, if it is found, it should be strictly dealt with. But again, as I am also an individual in the system, you are also an individual in the system.
Yes.
People will knock the door of the court, people will knock the door of the commissions, but ultimately we the people of India, as per the Constitution of India, we are the creators of the system, and we the only people of India, we can change the system. That is, that much I can say.
Thank you, sir. Thanks a lot.
So, can we call restraint of trade or legal action under the Contract Act as the germination of the competition law?
Restraint of trade, yes, restraint of trade is the principle that emanates first and then it is developed through these ideas, definitely. Basically, restraint of trade and then Constitution of India. Constitution of India is also prohibiting restraint of trade, business and profession under Article 19. And then it is going to be there in competition.
Okay, sir. So, I think we are done with the query. So, sir, can we formally conclude the session?
Yeah, I'm that is thankful to the body plea that definitely this particular, I feel that this area is untouched by many, but I am trying to give my level best to reach this area and to give solution to the problems and to give reply to your queries from my level best. If anything is not as per your will and wish, please pardon me. Thanks to all for listening seriously on this topic, on this issue. And thanks again to PLEA and everyone. Thank you all.
Thank you so much, sir, for such an illuminating session. It was a great learning experience for all. So, thank you so much for awakening us to this issue.
Thank you.
Thank you, sir. Bye, sir.
Bye.